May please your lordship. I mention item number 16, my lord. In this case, we record to file an affidavit, my lord, to respond some queries, my lord. We got the documents, we need 10 days time to file our affidavit.
Which for the other side?
BTC, my lord.
Have you informed them?
I will inform my lord. I could not got him, my lord. Affidavit, my lord.
The request is non-consent for the 2 weeks. Yes.
Hello.
May I beg to mention item 11. In this matter, I am led by Senior Counsel Mr. P.K. Goswami, who is undergoing some medical treatment, will undergo a surgery. Lordship. Therefore, I have informed the other side, there is no stay. Lordship. Though it has come in the column of stay matter, but there is no stay.
And the request of non-consent of the appellant list of petition. Appellant. Appellant list after 4 weeks. दोनों होगा 11-12. 11 and 12 are tagged.
11 to 15 are taken.
11 to 15. All the matters 11 to 15.
I am for item 11.
So what about the others?
Other councils, Lordship, I have only informed the other side. I could not, I'll inform just now.
Item number? Well, let the number comes then. Yes.
My lord, as regard item number 25, your lordship may close it because my lord, state government after filing, my lord, they have taken certain steps and my lord, I think nothing survived in the petition.
Let your turn, please wait for your turn.
My lord,
We'll pass it.
because I was supposed to file reply, my lord. When I have gone through affidavits, I found that state government has.
We'll pass it also. That's the number.
I please your lordship. My lord, regarding item number 28, my lord, this matter become infractious, my lord.
Okay, fine. Okay. Then a concept of the appellant has submitted that this writ appeal has become infectious, dismissed as infectious.
Highly obliged, your lord.
May it please your lordship. Lordship, with respect to item number 21, lordship, this matter has become infractious, lordship. Bank has already taken over the proposition.
Then concept of the appellant, petitioner has submitted that this writ petition has become infectious, dismissed as infectious.
Deeply obliged.
May I be Lordship? Lordship, I beg to mention item number 17.
Yeah.
My senior Mr. B. Sinha is out of absent today due to illness. Matter may be adjourned for the day, Lordship.
Have you informed the other side?
No, Lordship.
If you have informed, otherwise raise an objection there. Is there any stay?
My senior informed us.
Is there any stay in the matter?
No, Lordship. Today, fast listing.
The request of non-concept of the appellant is after 4 weeks.
Right.
Lordship, item number 35. In this regard, we have been recently engaged the matter and we'll file a vocal number today. So we will also inform the Standing Council for the Higher Education. The matter may be adjourned for 3 weeks.
Okay, Mr. So-and-so submitted that he has recently been engaged by the petitioners. Therefore, the last occasion we asked you regarding the maintainability of the petition.
That is there. We have been recently handed the brief yesterday only. We'll go through the brief and we'll apprise the issue regarding the maintainability. 3 weeks time.
Recently engaged. And therefore he failed. Sometimes you argue the matter.
29.
List up to 4 weeks.
My lord, I beg to mention, my lord, this is read appeal 436 of 2023. That will be listed on 6th of this month, my lord, because my lord, there is a stay order
And by lapse of time, my lord, the matter will be in fact was in 31st March. So, my lord, they are enjoying the stay order, and whatever, my lord, actually, the matter was listed on last occasion 9/1. Direction was given to, my lord, the admission that was given to listed after 1 week. But unfortunately, that matter has gone to the part 2 list in last occasion. And again, the same thing was happened, my lord.
6th.
Master.
My please, your lordship. My lord, regarding item number 2, we have, on behalf of NSI, I have filed a affidavit to the strength of that completion of work on 29 itself, but it is not in record. Am I allowed to bring on record, my lord?
You have already filed.
Yes, file on 29th, my lord, or should may take.
Then council appearing for the NHS has submitted that they already filed an affidavit indicating the progress
Yes, my lord.
in the project. Stop. Just after a week, along with the affidavit filed by the NHA.
Lordship, my date may be fixed, Lordship, in this matter, Lordship. Date.
11th of week, 11th of 11th वाले week में जो भी मतलब
Lordship fixing on
11.
11th in the week commencing from 11th.
Lordship, deeply obliged,
my
Lord.
lord. Obliged.
May I please do lordship? Lordship, I am praying for listing one lordship, fresh retable lordship on 6 lordship.
What's the urgency in this?
Lordship, matter pertains to lordship, eviction lordship. Eviction. Lordship. Dismissal. Lordship. Deeply obliged, my lord.
Item number 3, my lord. Adjourned for another 1 week, my lord.
Affidavit not received.
My lord.
At the request of the learned, you are for the appellant,
For the petitioner.
for the petitioner.
My
At the request of the petitioner, list after 4 weeks.
obliged.
Sorry, my lord, I have to, date is fixed on 15th, that day I will be not available on 14 and 15th. 15th, my friend is giving on 15th day, I'll be not available on that day.
Whatever, which
11th, it is probably only orders only to place. Or maybe, my lord, this as it is, we are completing by 31st March,
12th March.
12 March. Apply.
May I please, Lordship? In this case, my lord, I have not received any latest instruction. The matter was, my lord, placed before the finance department for
You
approval.
were supposed to. You were supposed to. The decision was taken a year back. But still you have not complied with the order this.
My lord, true from our part is what concern, my lord,
What
department
about
is,
the finance department? Why the finance department is not granted you approval?
my lord, in spite of my lord, repeated, my lord, communication, my lord,
Who is appearing for the finance department?
finance department, my lord, they are not party in this proceeding, my lord.
Whatever it may be,
My-
if the matter is pending with the finance
Yes, yes.
department, the advocate for the finance department should complete his instructions.
My lord. Finance department. Communication I'm learned, my lord, appearing for the finance department. I will furnish a copy to him, my lord, he may.
That
pursue.
state level committee has already decided to grant her compensate appointment. And this matter was referred to you on 2nd of March 2023. Still, the matter is pending consideration. It's
I will take the instruction, Lordship, will kindly accommodate me for some time.
Likhiye, Mr. So and so. Council appearing for the finance department is directed to complete his instructions that why the matter regarding compassionate appointment through the appellant has not been the matter regarding compassionate appointment to the appellant, referred by the state level committee has not been approved by the finance department. List on 13th of March,
Obliged.
while showing name of Mr. So-and-so for Finance Department as counsel for the, while correcting the name of Mr. So-and-so, counsel for the Finance Department in the cause list.
My lord, we are for 14th of March with all respect, one day, 14. And so obliged.
Okay, so much.
As per office note of 26 February, the service upon respondent number 4, 6, and 7 is yet to be completed, my lord.
Yes,
Service is yet to be completed upon respondent number 4, 6, and 7, my lord.
so. What steps you have taken for that, sir?
Yes, I have taken my registered post, my lord.
But those. have
There is
not
an
been-
office note, my lord.
But the notices have not been served till date. You have to take fresh steps.
Or lordship, in the writ petition, these respondents never participate. I'll take instructions whether they can be striked off, my lord. or not.
Take your instructions. In the meantime, take the steps for that. Okay.
Lordship.
Notices sent to the respondent number 4, 6, and 7 by registered post has not been served till date. Full stop. The net concept for the appellant raised for and granted time to either file either furnish fresh requisites for issuing fresh notices to the respondent number 4, 6, and 7, or to move appropriate application for deleting the names of the respondent number 4, 6, and 7 from the array of the respondents at the cost of the appellant. Just after 10 days.
Deeply obliged.
Respondent 2 and 3, I appear as the standing counsel for this.
Whatever the you give.
I'm
writing,
Obliged.
But it's a connected
Yes,
appeal, my lord. We have already served the copy. Possibly my friend is appearing.
yes. You are appealing for the respondent number 1.
Sole respondent, lordship.
So what do you want to say about the delay?
So, objection has been-
No objection, lordship.
That order?
Lordship, I have,
Whatever the delay. 169 days. 168 days. The order whereby we have condoned the delay.
Admit.
Well, I'll place a copy.
As per the service of notice upon the sole respondent is complete. This IA application is filed. With a prayer to condone the delay of 368 days in filing the connected rate appeal.
What is the number of delay? 168?
169 days.
169.
9 days. Lord.
169 days
9 days.
in filing the connected appeal. Then it concept of the applicant has submitted that in the similar matters, in the identical matters, this court has already condoned the delay in filing the appeals. So stop.
It will be.
Then it concept of the respondent number 1 has no objection if the delay is condoned. In such circumstances of delay of filing 169 days. In such circumstances, that this IA number so and so is allowed, and the delay of 169 days in filing the present appeal is condoned. Admit, no need to issue notices. Parties already been represented. Connect with writ appeal number 50/2024.
Okay. So now what do we look at? Copy is readable, copy is whatever.
Met please your worship. My lord, it is barred by time, my lord, writ appeal.
The notice upon the response.
337
have not been served.
days. My lord, this respondent number 1 appeared, my lord, whether they have got any
8
objection.
and 9.
My lord.
The service of notice upon the respondent number 8 and 9 is not complete.
Then we have to take fresh step, my lord.
Okay, as per the office report, service of notice upon the respondent number 8 and 9 is not complete. Full stop. Applicant is directed to take steps for service of notice on respondent number 8 and 9 by registered post with AD within 10 days from today. On doing the same, let notice be issued to the respondent number 8 and 9, returnable 4 weeks thereafter.
Oblige me.
In the meantime, your lordship, I am for respondent number 1. In the meantime, I will file my objection, your lordship.
So,
Oblige.
But there is IA for delay of condonation of 283 days delay, my lord.
83 or 273? 73 or 283?
283, my lord.
Here it was, we have noted 273.
Lordship.
As per the office report, notice.
Notice has been duly served, my lord. We have filed the affidavit.
Respondent number 1. Notice upon the respondent number 1 has duly been served. However, no one is appearing on behalf of the respondent number 1. Which of this IA is filed on behalf of the applicants with a prayer to condone the delay of 270 days in filing the 73 days in filing the connected appeal. Having heard the learned counsel for the applicant and after going through the contents of the application, we deem it appropriate to condone the delay of 273 days. Hence, the IA number so and so is allowed. Delay of 273 days is condoned. Admit, issue notice to the sole respondent. IA disposed, IA disposed of. The registry is directed to register the connected appeal and list for admission after 1 week.
Well, in item 8, we have served dusty notice, but at that point of time, he was not present. At his home, well, it was possibly we have to take fresh notice. Lordship may allow us to take fresh.
As per the office report, at the time of service of notice upon the respondent number 1, he was not present in his at his residence. Let fresh notice be issued to the respondent number 1, be served through registered post AD. Requisites be filed within a period of 1 week on filing of the same. Let notices be issued to the respondent number 1, returnable 2 weeks thereafter.
Lordship. But we'll take registered only, my lord. No dusty is to be taken here.
Registered post AD.
Lordship.
Made Lordship, I mean, there is an application for correction of the typographical mistake, my lord, in the PIL. So, if I explain in paragraph 1.
One for consideration of the IA number so and so, with a prayer to allow the petitioners to make certain corrections in the
PIL, my lord.
in the para number.
Para number, my lord,
Para number 1
second cost title and
of
para
the
number 1.
present PIL. Full stop. The, having gone through the contents of the application, we deem it appropriate to allow the same. The proposed corrections in the para number 1 as well as cost title of the writ petition are allowed. The corrected copy of the writ petition be filed within a period of,
2 days itself.
within a period of 2 days.
No, within 2 days, man, 2 day.
Today itself, be filed today itself. Next after 2 weeks.
Can it be bit earlier, minor? Can it be bit earlier? On Tuesday next, my lord?
List on 12th of March.
Yeah.
May I please, your lordship, proceed, please. See, there is a delay of 162 days in preparing the appeal lordship. But say, may I notice may go because the first time it is listed.
Should notice of the which of requisites we filed within a period of 1 week. On filing of the same, let notices be issued to the respondent number 1. Be served through registered ID,
Much uplift,
returnable after 4 weeks.
much uplift.
May it please, my lords.
Yes,
I'm appearing in item 12 and item 13. My lords. This is a very important matter, my lords. This is after demolition. Almost 1 year has passed, my lords, and this is pending before your lordships.
yes,
My lords, two very important questions of law are involved in this case, my lords. One, that can a prospective legislation be allowed to be executed retrospectively? And number two, that can a demolition exercise be carried out within a period of 12 to 14 hours without serving any notice upon the affected parties, even if they do not claim any rightful ownership on the land? So those are the two questions, my lords. This will take some time, about 20 minutes for me to argue.
the council in item number 11, which is also connected, this rate of the rate appeal.
My lords,
There is a request on the part of the council for the appellant for adjournment on account of some personal difficulty.
my lords, my prayer is that since this is a demolition matter and item 11 is basically an association,
Just a minute, demolition has already been carried out
it has been.
and we can't pass any stay order for status quo ante.
I understand, my lords. I am not on that, my lords. What I'm actually praying for is that this be heard as soon as your lordships please.
We will do that.
May it please, your lordship, this matter, our matter is a matter of land and acquisition, lordship. We are valid allotment holder. The other matters are encroached.
We have,
Therefore, it
land
can
was
be said-
allotted to you, but for the purpose of this preservation of a bill, now they have issued a notice for rejectment for eviction, or they propose to acquire your land.
Propose to acquire our land, lordship. Therefore, lordship, what I pray, lordship, this matter can be segregated if there is any urgency.
Ultimately, all these matters are related to this
Hilaku bill.
The bill in question.
Yes.
So that
Can I
has-
assist? Can I assist your lordships for a minute, my lords?
Lordship, then I pray for adjournment for today.
Can I assist for a minute, my lords? Can I just take 30 seconds?
Yeah, okay.
Yes, my lords. So, my lords, the reason why I'm claiming urgency is, my lords, because in item 12 and item 13, these are very poor people. Today, they are forced to live in very dire circumstances. Their houses were demolished. And after that, today, it is a violation of Article 21 rights in dito, my lords. That is why this has been pending for a year, my lords. Rehabilitation, accommodation, compensation has to be done.
The most direction can be issued for rehabilitation.
Absolutely, my lords.
Persons.
That is the prayer, my lords. That is the actual prayer, because this is a violation of, and also
the learned single judge has already issued the direction of this effect.
no, my lords, that was never considered. So we have obviously also filed applications after that, but that was never considered. There's a land policy in Assam, and this entire process, my lords, the way in which this demolition was carried out, it is very sad and unfortunate, my lords. I need to point out that to your lordships. Can I just tell, can I? What has happened is, my lords,
In this matter, still the notices have not been issued to the respondents.
it has been issued, my lords. Everything has been issued.
In our matter, notices was not issued,
Your matter notices have not been issued.
not been issued.
What has happened is that, my lords, these people.
Wait for your turn.
No, not books. Okay. Yes, sir. Continue. Let them. All India.
But your matter has already been admitted, Mr. Gonsil.
Yes, my lords, it has been admitted.
It has been admitted, then we'll post it for hearing.
Yes, my lords, that's what I'm praying for, my lords, that a final hearing may take place on this matter as soon as your lordships please.
I think retail 253 has not been admitted yet.
And notice has not been issued as yet in item number 11.
Okay, item number 11 में admit Mr.
R. Pujari, my lord, and Mr. Standing Counsel for the Revenue Department.
Mr. R. Pujari, standing counsel for the Revenue Department, is directed to accept notice on behalf of the Revenue Department. That notice be issued to the other respondents. Returnable 4-5 year appealing.
And
Mr. So-and-so is appealing on behalf of the respondent number 4-5. And 10.
Service completed. He's for 123 and he's for 4.
He's for, Mr. R. Pujari is for 123 and Mr. So-and-so for remaining respondent. Service is therefore complete. This matter along with the connected appeals for hearing in the third week of March 2024.
May your lordships consider 15th March, my lords?
Third week of March.
Please, my lords.
And so.
एक मिनट
May it please your lordship.
Yes.
Lordship, we are led by Mr. Chinmay Pradeep Sharma from Delhi. Actually, within some matter, the matter may be passed over for the time being. After some time, it may be taken.
So, no, he wants VC and then he is busy in a matter, so.
He's caught up in some other matter. After some time.
What do you mean by after some time? Last item.
My lord. My lord, in item number 17, lordship petitioner said they have taken time without informing me, lordship. I was waiting. And I don't know, lordship, how much time they have taken.
So only I asked him that whether you, but is there any stay?
No stay, lordship.
So what do you want now?
Lordship, how much time, lordship?
4 weeks. We have already done.
After a week, lordship. After 1 week, lordship.
But there is no stay. How you are affected? The order of the learned singles is in your favor.
Yes, lordship.
Let them seek adjournment for whatever time you may enjoy the fruits of the
Lordship,
order.
because pendency of this lordship appeal, lordship, the authority, we have facing some problem, lordship. For
In the case in the 17th, at the request of the council for the and just after 4 weeks, hour, it is made clear that no stay order is operating in this appeal. That's enough.
lordship.
May please, your lordship. This inter-court appeal has been filed, my lord, against the judgment and order dated 11/1/2024, my lord, whereby my writ petition was dismissed, my lord. Before going into the, my lord, the brief of the case, my lord, may I take your lordships one document at Annexure P at page 59, my lord.
Yes.
Yes. This is the document, my lord, whereby the government has advised, my lord, what are the documents to be submitted for submitting tender in a fishery, my lord. May I read the clause 1, my lord?
Yes.
100% actual fisherman certificate. Submission of 100% actual fisherman certificate of fishermen cooperative societies, self-help group, NGOs issued by the ARCS, indicating that all the members of the fishermen cooperative societies, SSG, NGOs are actual fishermen belonging to the scheduled caste community of Maimal community of the Archwell Kasar district of the Assam, my lord. Thereby, my lord, the 100% fisherman certificate issued by the, my lord, the Assistant Registrar of Cooperative Society has to be submitted.
नाम लिखा Dining council
Issue of this.
My lord. This 100% fisherman certificate has to be submitted along with the
Issuing notices of the appeal to
My
the
lord.
other party.
My lord.
Issue notice. And Ms. So-and-so is appearing on behalf of the
Fishery Department.
Fishery Department. Let notice be issued to the respondent number 3, 4, and 5.
3 and 4 I am appearing.
We are appearing, Mr. So-and-so is appearing for the respondent number 3 and 4. Let notice be issued to the respondent number 5 only. Returnable, 5 only, requisite to be filed within a period of 1 week on filing of the same. You are for the respondent number 5. Okay, Mr. So-and-so is appearing on behalf of the respondent number 5. You have instructions, you have filed power. You have filed power on behalf of the respondent number 5. Wakalatnama you have filed.
Actually, last Friday I saw it on this so my senior has used to not start the copy and in Wakalatnama my name is not filed.
My lord, there is no caveat, my lord. Caveat is not there, my lord.
Have you filed power on behalf of the respondent number 5? Wakalatnama.
Please not have.
My lord, she is a newcomer to the.
We are issuing notices, you may appear in the court, na? When after service of notice, you may appear. Let notice be issued to the respondent number 5, returnable. The requisites be filed within a period of 1 week. And the notes, and on filing of the same, notices, filing of the same, the notice be issued to the respondent number 5, who registered daily, returnable 2 weeks thereafter.
May I prefer some interim protection, my lord?
After hearing the respondent number 5, will grant whatever
What is the interim you are praying? Your writ petition has been dismissed.
Dismiss, my lord.
Writ petition should be allowed in the interim.
No, my lord, that, my lord, the impugn order, my lord, whereby settlement has been provided, my lord.
File an application.
Oh, my lord. Deeply obliged.
Lordship, perhaps the service is not complete in this case, Lordship. We've taken steps on 29/1, Lordship. Notice has already been issued and there is an interim order also, Lordship.
Notice of solar type. Await return of notice of the respondent number, sole respondent for
Lordship. Lordship, and the interim order may continue, Lordship.
3 more weeks, interim order if I need to continue till next day.
Oblige your Lordship.
May it please, my lord. My lord, hearing the petitioner, the appellant, my lord, she had challenged the appointment of the respondent number 5 as the headmistress of a school in Jorhat, my lord. My lord, thereafter, the ground of challenge primarily was that, my lord, the respondent number 6, my lord, did not have continuous service for a period of 10 years, my lord. And there was a break in service after 9 years, my lord. My lord, thereafter, the learned single judge, my lord, if your lordship kindly comes to page number 106, had sought for the reply of the state government, my lord. This, on another occasion, the reply had been sought for, my lord, but there was no reply filed. Thereafter, the learned single judge went on to dismiss the petition, my lord, on the ground that at the time when the appointment happened, I was not qualified, my lord.
Then how can you claim this appellant was not having the qualification for appointment on the post of headmaster at the relevant time?
Lordship.
Then how can you challenge the appointment of the other person? Not a writ of quo warranto. You have prayed for your appointment on the post of headmaster in the writ petition.
Lordship.
So it was not a writ of quo warranto.
Lordship.
That is what remains.
But at the time of challenge, she had acquired the qualification and
At that time in the year 2010, the advertisement is of 2/11/2010. At that time,
Advertisement is 2010.
10, my lord.
2010.
2010.
Challenge after 6 years.
Once you are not having that qualification, then what remains?
Lordship, in essence, it was quo warranto, your lordship.
Essence is somewhat different. If you are seeking this appointment of, if you are seeking a declaration that the appointment of the respondent number is declared as illegal, then certainly it's a quo warranto. But you have also prayed that the petitioner or appellant should be appointed on the post of the headmaster. That is not.
Lordship, another aspect is that the learned single judge did not trust me in the sense that when I said that she had a break in service, that contention was not accepted.
First of all, you are not having that qualification. Certainly, learned single judge is rightly not interfered in the matter.
Lordship, but one aspect your lordship may kindly not grant finality is the question of continuous service for the period of 10 years, my lord.
That the learned single judge is also considered and found that no, there is no break of there was no break in service.
Yes, your lordship. If your lordship in at page number 115.
What you would get out of it?
I am no longer headmistress, Lordship.
You are not.
School has been amalgamated. Now
was
has been with a separate school. I am no longer headmistress.
But lordship, if I pursue any other remedy with respect to the continuity of service, my lord, that question may be kindly left open.
You withdraw it and have your liberty as and when occasion arises.
Lordship, this finding of the learned single judge may not be fine.
No, not at all, sir. We are not going to disturb that finding since she is no more now respondent number 6 is no more a headmaster. What remains the matter is
because your lordship seniority may also be affected. She is also
at that time when the question of seniority arose, you may raise that question in appropriate proceedings, not in this petition.
And there was another, the respondent number 6 was ordered to return certain pay she had received for that period of leave that was cancelled.
This writ appeal is filed by the petitioner being agreed with the order dated 2/3/2023, challenging the appointment of the respondent number 6 as headmaster of
BDS Memorial High School, my lord.
BDSM Memorial High School pursuant to the advertisement Jorhat pursuant to the advertisement issued on 2/11/2010. Stop. The learned single judge has dismissed the writ petition, concluding that there is no illegality in the appointment of the respondent number 6 as headmistress of the school concerned simultaneously, the school concerned, simultaneously, the learned single judge has also observed that the appellant was not having the qualification for appointment on the post of headmistress in the year 2010, when the advertisement, when the related advertisement was issued. Full stop. Where it is informed by the council for the your respondent number 6 here, the respondent number 6 here in appeal, that due to amalgamation of the BDSM High School Jorhat in
With Jorhat Vidyalaya in the year 2022.
with the Jorhat Vidyarthi Vidyalaya in the year 2022, the respondent number 6 is no more. Is now not working as a headmistress.
Is retired.
Retired.
She is retired.
No, I am working as an assistant teacher. I have been
And is working as assistant teacher only.
in the amalgamated.
Consideration, the above fact has not been disputed by the counsel for the appellant. Also, taking into consideration the above fact emerged, above subsequent fact arose in this matter, and also taking into consideration the fact that the writ appellant, that the appellant was not having qualification for appointment as headmistress in the year 2010, when the related advertisement was issued. We don't find any case for interference, hence this writ appeal is dismissed.
My lord, any observation with respect to the break-in service?
We already asked you to, if you want some observation or whatever the liberty, withdraw this writ appeal, but since you have not chosen to it. Yes.
I'm obliged.
Item 23.
On affidavit, they said, Lordship, in terms of your lordship, last direction, lordship, on additional affidavit has already been filed on.
When?
Lordship, it was filed on Saturday, law, recent law. Probably not in that. Remember, more to the
So now you dropped almost all the audit objections.
Yes, Lordship.
All-
Now it's 20 law. Altogether, 43 allegations were there.
20 remain.
As of now, Lordship, 20 has already been dropped.
And what about the
One has been forwarded to the Public Action Committee, Lordship. So remaining, Lordship, last queries has been, replied on recently, Lordship, on 3rd of January 2024. So we are,
filed the additional affidavit?
yes, Lordship.
The counsel for the appellant has the respondent has submitted that pursuant to the direction given by this court on 5/2/2024, the additional affidavit has already been filed. Full stop. Office, you want to file reply to that additional affidavit or
No, my lord, it's.
We'll go by their affidavit, my lord.
you go by the Learned, but the copy of the affidavit is not tagged along with this. Along with this writ petition, office is directed to tag the same and this matter after 2 weeks.
Mal. Obliged. Item 24.
My lord, kindly have a look at, my lord, at a previous order dated 2011 to 23, my lord. My lord, matters relating to the
prevention of flood of the petitioner's area. And as per earlier order of this court, SIM has been taken. The Central Water Commission requires detailed project report, and that was submitted. They are saying that there is some discrepancy that should be removed.
So they have submitted now the revised DPR.
Yes,
Lordship.
What happened to that, when you have, they sent this revised DPR,
Lordship, on 15/11/2023.
what happened to that?
Lordship, after that, Lordship, in the month of February, a team of the Central Water Commission had visited the site. And after that, we are not aware, Lordship. In the month of February only.
What happened to your DPR? That DPR was approved or not?
That CCC will be able.
Deputy Solicitor General of India was supposed to. Where is he? Where is the DSGI?
My lord, Mr. RKD Chaudhary is appearing, my lord, in the on behalf of.
I'll inform him.
Password,
Time being.
My.
Item 25.
I was supposed to file a reply to the affidavit filed by respondent. In the affidavit.
Yes.
Well, in the affidavit filed by state government, my lord, they have taken the stand that they have annexed, my lord, certain documents also. That they have affidavit filed by state government, your lordship. So they have already proceeded with the matter and they have issued notices to the concerned person. So I think, my lord, nothing to be adjudicated. They are proceeding in the matter.
This petition in the design of public interest petition is filed on behalf of the petitioner. On behalf of the petitioner to issue amendments to the respondents to issue necessary directions banning the pan masala and gutka companies from manufacturing, storage, transportation, display, distribution, or sale of gutka pan masala or any chewing material containing MgCO3 ingredient. Full stop. Is the reply to the petition is filed on behalf of the
Respondent 4, Lordship. Respondent 4.
Respondent 4
Has
written the action taken against the violators for which the grievance has been raised in the writ petition as indicated. Stop. Learned counsel for the petitioner has submitted that since the state government, since the board has already initiated action against the respondent number 4 has already initiated action against the persons who are violating, who are indulged in irregularities and violations. Nothing, the purpose of filing this writ petition, filing of this writ petition is rectified. Hence, no further order is required to pass in this petition. In view of the submissions made by the counsel for the petitioner, this PIL petition is closed.
Deep.
Respondent number 4.
Respondent number 4, not board.
Respondent number 4.
Item 26.
But I have received the instructions, my lord. In fact, on the first date, my lord, on 20th of September, when Lordship has issued notice in the matter, my lord, Lordship has directed us to obtain instruction as regard the action taken by the respondents in respect of another similarly situated persons, my lord. I have received the instructions that his case has been rejected by the authority, my lord. It is not considered. And in fact, that petitioner, that person, he has filed another writ petition. It has been listed today, my lord. And I have received the other instructions also. I'll bring it on record, my lord, by filing affidavit, my lord. Give me 1 week time, my lord.
Yes.
My lord, matter is very simple, my lord. By their own mistake, the chief engineer has admitted that by mistake 2 names were left out for regularization. And subsequently they have forwarded it. But the government has not considered it. It is not my fault. I am a master worker. Even then I have done everything in time.
But what about the London single judge has taken into consideration the.
They have not considered. I have come to, today I have come to know, they have not considered. I have filed another writ petition for that matter. Earlier division bench has directed to consider it.
Okay, Mr. Veena, counsel appearing for the state has submitted that he is furnishing the details about similarly situated persons within a period of.
I need 1 week time.
Within a period of 1 week.
Lordship.
This matter after a week.
Lordship. Give me, hold on.
Item 27.
Well, in item 27, the respondents, they have filed an affidavit in the matter, my lord. But I need some time to take the instruction in the matter. Let me have an instruction on that. Now, hold on, there are file process file process maintainable. Okay.
If they work for that promotional post, why not the monthly salary and all the.
Well, the Anganwadi workers, they are not holding a public post.
They are not holding.
They are not holding a regular public post, a civil post. They are Anganwadi worker and helper. They are working under a scheme and they are on honorary basis. So for the first time, when they joined the post of supervisor, they enters the government service. Without the concurrence of the finance department, the regular salary is not possible to release. And from the month of August 2021, they haven't given the scale. Lordship may give me some time, my lord. They have filed the object, affidavit and
Lord,
objection, my lord.
in
Let
fact,
me-
my lord, I have a preliminary objection on this case, my lord, because the writ appeal was filed after 16 months of the judgment without any application for condonation of delay, my lord. And therefore, my lord, writ petition is admittedly barred by limitation. My lord.
Why this was not taken note of the registry?
My lord, that's I.
You have taken this objection in your.
Affidavit, my lord. I have filed affidavit, that affidavit also tag with it.
Okay. Then the concept of the appellant has submitted that. And affidavit is filed on behalf of the respondents. Taking certain preliminary objections. And also on the merits of the case, he placed some time to file counter to said affidavit. Time period for is granted list on 1st of April. Huh?
Time being item 24.
Please, your lordship.
Yes, Mr. Chaudhary, what happened to your DPR?
Lordship, DPR, they were required to submit for the state was required to submit and
They have already submitted.
they, Lordship, they had submitted earlier, but there were some certain queries that were raised. And my friend has
Now to meet those queries
that they have submitted, Lordship.
on
my-
15/11/2000.
Yes, Lordship.
Yeah.
And he says some inspection was carried out this month. I'm sorry, February, Lordship. Lordship, if Lordship posts is on Monday, Lordship, I'll take the updated instruction.
Monday.
On Monday,
At the
Lordship.
request of Mr. Chaudhary. At the request of Mr. Chaudhary, list this matter on Wednesday.
Day after tomorrow? Next. Next.
6th of March. Sorry. 13th of March.
I'm so obliged, Lordship. Okay.
Item 29.
May I please, your Lordship?
Yes.
This is against an order dated 17th November passed by the learned CAT regarding holding of review DPC. If I may take your Lordship to the order, Lordship will find at page 15. In fact, this order was passed in the second round.
Page?
Page 15, 1/5, Lordship.
1/5. Yes.
In fact, there was an order passed earlier.
In
Against,
2014.
yes, Lordship. Against that, we had come to the Honorable High Court. And High Court had remanded the matter back to the CAT again. And in terms of that order, this order has been passed by the learned CAT. And the CAT, if I may take your Lordship up to page 17.
Yes.
paragraph 4, Lordship. After perusing the documents herein produced by both sides, it is observed that ad hoc promotions are made on 22/1998, Lordship, that is not disputed. As recorded in paragraph 32 of the order of the ad hoc promotion, could be given only in 3 stated circumstances. This I dispute. But the ad hoc promotions which were given on 22/98 without there existing any of the 3 circumstances, as such, the respondents are directed to hold regular DPC as on 22/98 instead of having given ad hoc promotions on that date. In place of para 33 of the order dated 4/7/2014, I'll take your lordship to that. Para 4 above of this order be replaced. Now, this, in fact, in my humble submission, lordship, no determination as such by is only merely substituting a paragraph.
What was the direction of the court? Was this court?
This court, lordship.
They have quoted.
Yes, they have
following
quoted.
observation.
They have quoted, lordship.
In the output people.
At page 16. Now, all the prayers made by the applicant in the before the tribunal, they were rejected.
By the way, when was the 2014 order?
I'm coming to that, lordship. You'll find it starts at page 157. And lordship may be pleased to look into from paragraph 27 onwards of the judgment. Lordship will find it at page 171.
(171) of this paper book.
Yes, lordship. If lordship will see, if your lordship has found paragraph 27 of the judgment.
Which page? Which page?
Lordship, in the paper book, it is 171. Not matching.
Page some.
Lordship, paragraph 27 of the order, lordship, of the tribunal.
Internal page 15.
Huh?
Judgment page 15.
Internal page 15 of the judgment, lordship.
I think the judgment starts from 150. Page number 150 of the paper book.
Lordship, I'm very sorry, lordship. There is some mismatch in the paper book, lordship.
So the numbering you are following, that has been erased in our paper books by Whitener.
Oh, lordship, I may be allowed to correct it. Otherwise it will cause a problem, lordship.
This one 14th.
I'll have it on
14th. Is earlier matter?
Yes, yes.
It's not
But Lordship will allow me to make the corrections. Right.
permitted to correct the pagination. Mr. Chaudhary is permitted to correct the pagination in the record. Pagination in the record. Just on 14.
Item number 30.
Yeah, please, Your Lordship. My lord, this matter pertains to promotion of the petitioner from the post of laboratory BRI in the zoology department.
Which item you are appearing?
This is item number 30.
I'm sorry, madam.
So the learned amicus was supposed to address the honorable court, my lord. Otherwise, the report has come, my lord. The state legal service authority, they have given a report as regard the shelter homes available in the entire state. In fact, the report says that there is no shelter home in the other part. Only one shelter home at Hojai, it is there.
The report is dated.
The report is dated 5th of October 23, the letter by Member Secretary, State Legal Service Authority to the Register Judicial.
Of October.
Kindly, yes, 9th of October 23, Lordship has referred in the order.
The report of the received the report. Inspection of the So the report suggests that most of the districts.
In fact, only in
Temporary shelters were not found.
no.
In any 33 districts of the state of Assam.
Yes.
So the permanent shelter homes are there.
No. It was a temporary shelter home at Hojai because of some eviction drive. And it is already because of some eviction drive.
Eviction
drive.
Yes.
Lordship, as today my senior has some personal difficulties from his end. Lordship, may this matter be taken up after 3 weeks?
The State Legal Services Authority has submitted its report before this court on 15/10/2023, which was taken note of. Wide order dated.
Well, report is of 5th of October. It is typographically.
5th of October. And it was taken note of, taken note on 2023. Should stop having taking into consideration the issue involved in this writ petition. We are of the opinion that the State Legal Services Authority is required to be included as party respondent in this petition. Hence, we direct the registry to include Assam State Legal Services Authority through its member secretary as party respondent in this writ petition. The documents pertaining to the writ petition be supplied to the member secretary, Assam Legal Services Authority within a period of 10 days from today. List this matter after, list this matter on 2nd of April 2024, while reflecting the name of standing counsel of the Assam Legal Services Authority. On the call list. On the call list.
Obliged. Is it fine?
Item 31.
May I please, your lordship? My lord, the appellant herein is a laboratory BRR in the Department of Geology in Sri Kishan Sarada College in the district of Hailakandi. His case for promotion to the laboratory assistant of the same college, my lord, was rejected. Initially, he had approached this honorable court with a writ petition, my lord, claiming for promotion, my lord. And page 35. And my lord, this honorable court had directed that to consider his claim as per rules, my lord, along with other eligible candidates.
That writ petition.
Accordingly, the DPC.
That writ petition was disposed of on 24th of January 2020.
Yes, my lord. Thereafter, the DPC considered his case, my lord, recommended his case for promotion. But, my lord, that was not considered, for which the petitioners had approached this honorable court in page number 68, second times, my lord. And this honorable court held that due to lack of qualification, his promotion cannot be considered on the basis of a notification of 9/2/2017. So, my lord, may I first draw your lordship's attention, my lord, page 60. Notification, my lord. DPC director. 42. 42.
Qualification. Appellant is a graduate.
My lord, sorry.
Appellant, your client is a graduate.
He's
No,
graduate.
my lord, no, my lord, no, my lord.
Then how can he be?
My lord, my lord, notification 9 to 17, my lord, with humble submission, my lord, I beg to mention that this notification is, my lord, nowhere is mentioned that this is for promotion, my lord. What, my lord, appeared, my lord, that this notification is for direct recruitment, my lord. What appeared in page number 60, my lord, guidelines, my lord, that regarding, my lord, written examination is there, and, my lord, marks is also allotted, my lord.
Yes.
My lord,
I will not kindly have page 496 of this book, my lord, the rules, my lord, which is. Page 496, my lord. But the petition is governed by these rules, my lord. The service of the petition is governed by this rule. My lord, rule 5 is the method of recruitment. The relevant is, my lord, rule 5, sub rule 5, my lord, 498, page 498.
The post of lower division.
Yes, my lord. The post of lawyer division assistant, laboratory assistant, library assistant shall be filled up by direct recruitment and from laboratory bearers, grade 4, having qualification as prescribed, my lord. Having qualification as prescribed in the ratio of 75:25. My lord, the for direct recruitment as well as for promotion, my lord, the candidate has to have qualification as prescribed, my lord. Now, this rules doesn't provide any qualification for, my lord, direct recruitment or promotion. That's why, my lord, the department, my lord, the page 60, my lord, page 60 of this appeal, my lord. The department has issued this memorandum, my lord. This memorandum is for promotion as well as for direct recruitment, my lord. And here also, page 61, the educational qualification says, my lord, page 61, educational qualification shall be graduate in arts, science, commerce with a diploma or certificate course of computer operation of minimum 3 months duration. One should have the working knowledge of Assamese and English typing, word and simple. So the petitioner, the candidate has to be, has to have prescribed qualification as per this OM, my lord, which is graduate. And admittedly, my lord, the writ appellant is not a graduate, my lord. That's
When
why.
did he enter service?
my
Initial
lord,
date of
2004, my lord, initially. And it is, my lord, regularized in 2009. My lord, may I know your lordship?
And his case of promotion was considered in the year, my lord, 2000. 2017. He applied for promotion, my lord, in the year 2016. And my lord, now it is also settled proposition of law that the service rule or in case of promotion also, my lord, is will covered at the time of the rule prevailing at the time of consideration.
But what happens when people were appointed before the rules came, rules were framed? And in their case, there are judgments of this court on this particular issue. You have not brought it.
But my lord, the recent, if I may submit, my lord. The Himachal Pradesh, my lord, judgment. These judgments, my lord, overrule the Rangaya judgment, my lord. This, para 36 onwards, my lord. This judgment, my lord, over.
Para 36.
36 onwards, my lord. It says that, my lord, this,
The review of the 15 cases.
yes, my lord. Earlier, my lord, in earlier paragraphs, my lord, preceding paragraph, some rules has been discussed. Now, the final, this final observation is that, my lord, the rule prevailing at the time of consideration will be, my lord, prevail. Yes, Mr.
My lord, page number 63, my lord. May I draw your lordship's attention to the notification minute 9 to 17. My lord, it is mentioned, my lord, page number 62, my lord, last line, my lord, page number 62. Please ensure that the posts have been released for direct recruitment and no proposal for regulation shall be entertained. So, my lord, this notification means for direct recruitment, my lord, which is again page number 63, my lord. Again mentioned, my lord, please ensure that.
So that there is no provision, there is no provision under these rules which provides this qualification on the post of LDC by way of promotion.
Yes, my lord. Moreover, my lord, the notification itself, my lord, reflects that it is for direct recruitment, my lord. Page number 63 also mentioned, my lord, that it is.
Even if
Please, my lord, page number 63, please ensure that the above mentioned guidelines for selection of grade 3 direct recruitment post, my lord.
that is not. This, read the opening part of this memorandum.
Yes.
The Government of Higher Secondary Department guidelines holding selection so and so after all, then the colleges or professionalized Assam college so and so were framed. Rule 5 of the said rule under some rule state that the post of lower designated library shall be filled by direct recruitment from the library bearer, grading so and so as prescribed ratio. The rules do not prescribe guidelines and so and so. Since many of the OAs have been issued, then notifying the local employment exchange.
That is, my lord, sub-rule 5 is mentioned, my lord. But my lord, what my submission is that, humble submission is that, my lord, as mentioned in the notification itself, that it is only for direct recruitment, my lord.
My lord, my lord, this is different, my lord. What my learned friend is pointing out, my lord, this is prohibiting regulation.
The net concept of the party. We are of the view that matter required consideration and admit no need to issue notices, parties are already represented. Just for hearing in the due course. Yes.
Supplementary list, item 39.
My lord, some area bases were to be cleared, my lord. We were, my lord, as per our commitment given earlier, by February, my lord, we were supposed to remit the amount,
Naturally,
my lord.
What
But then what has happened in February, my lord, because of some calculation error, only 60% of the amount has gone. Now in the salary of March, my lord, the balance payment is go, my lord.
you'll pay the balance in the
60% of the areas have been paid, my lord.
60% of the, what about the remaining?
It will reflect in the salary of March, my lord. This is the statement, my lord.
Okay, yes, Mr.
Yes, Lordship, they have paid, they have received the amount, 60% amount. If 40% is paid, then
Okay, learned, concept of the respondent has submitted that the 60% of the area of payment of wages has already been paid to the 6 left out working cases and assured this that the remaining 40% of the arrears of remaining 40% of arrear of payment of wages will be paid to the remaining 6 to the 6 left out working cases in the month of March 2024.
Along with your separate.
Along with the due salary. Full stop. This matter on 3rd of April.
My lord.
Lordship, there are other two.
There are three connected cases that has not come up today, my lord.
Yes, records are there, but.
I'll furnish the case numbers. 81 of 2018, 83 of 2018, and 466 of 2023.
List along with, list this contemplation on 4th of April along with the other connected matters which record is already available.
Record is there. 81 of 18, 83 of 18, and 466 of 2023.
You get it confirmed. Confirm.
Yes, God will say in the list or
Deeply obliged.
Obliged, Lordship.
Item 40.
But I have filed the dusty affidavit, my lord. Has been served, my lord.
Wait, please, Lordship. Lordship, I'm appearing for respondent number 3. We have filed our Wakalatnama on the last occasion. Lordship, we have written for the instructions when we'll be.
Yes.
I'm appearing for respondent number 3. We have filed the Wakalatnama for respondent number 3. Lordship, may kindly fix it, give us some time, we'll get our instruction. My friend.
No, the issue herein is that the petitioner, he is on fixed pay since 2010 and without any promotion since 2010. This honorable court, my lord, granted relief to the petitioner.
And my friend has given me a communication saying that they have filed SLP. My lord, I can give the status of the filing in the SLP. They have simply filed a petition there and with lots of defects, and they are sitting tight over the matter. Lordship will kindly consider whether they can go like this, my lord. Defective matters not refiled after 90 days. Sorry.
You are Mr. B Naik.
So I'm A Fukan, Your Honor, for respondent number 3, Your Honor.
The respondent earlier, and Mr. P. Naik Leonard puts in opinions on behalf of the respondent number 3 on the last occasion.
Yes, Dr. Van in terms of lordship, last order lordship, we immediately contacted the department lordship, and department forwarded that letter lordship. One letter wherein it has been stated, reported by the advocate on record lordship from the Supreme Court, that in the coming weeks, starting from 18th lordship, the matter is going to be listed lordship. One stay petition also pending there.
And your lordship's judgment is of 28/4/2023. It was communicated to the respondents on 8/5/2023. They may pursue with their appeal, but in the meantime, they should implement this order of the judgment of this honorable court, my lord.
So what is so difficult in complying with the order? He's been working all throughout. There is cabinet decision, there is.
Lordship, as I have been informed, lordship, department is aggrieved by the fact that an order has been passed to amend the rule, lordship, in a particular manner. That is
Order
the-
has been passed to amend the rule.
Yes.
Where is that?
Where is that direction?
Twenty-five, lord.
Yes,
Paragraph
which paragraph?
22.
Which paragraph?
22, lord.
Para 21, my lord.
21, lord. So sorry, lord.
Not a direction simplicity for amendment of the rules.
Yes, lord. Paragraph 22, last two lines, by carrying out necessary amendments to the rules of 1963 so as to integrate the post of DO with the cadre of junior administrative editor.
Don't amend the rules, but you pay him. The order clearly mentions that it is a direction to protect the rights under 14 and 16.
And nothing else.
If that requires amendment of rule, you'll have to amend it.
Simply it is an observation.
Lordship, just I'm at this stage, lordship, I'm only praying for adjourn this matter for 2 weeks, lordship. Let the matter get listed before the Supreme Court, lordship. Once stay petition is pending there, lordship will take up this matter after 2 weeks, 3 weeks, lordship. If no stay is there, lordship will definitely comply, lord.
Still, since 2023, there is no stay, you have not complied with.
Lordship, the matter. Letter one, sir. Department of letter one. The SLP number has been given, lordship. It's a diary number 47783.
Mr. Nayak, why don't you read from beginning of para 21?
Exactly.
Yes, that line is there.
Then
it may be correct to say that ordinary no direction can be issued to court to amend the provisions and so and so. However, what is to be noted here that the basic relief sought by the appellant in this case is providing him opportunity to carry provision and benefit of the revision, which would not be possible unless the post held by integrated into the existing cadre. Denying promotion which has benefit of pay revision similarly situated employees, Department of enjoying so and so, were arbitrarily infraction and fundamental rights under Article 14 and 16. Implementation of the 7th Pay Commission as approved by the state would therefore address the basic grievance of the applicant. The exponent authorities were under obligation to implement the mandate following by the cabinet decision. More so when the same relates to the question of providing, protecting funds of the respondent in discharge, the action that is called for in the case issue of mandamus for enhancement of the appellant, Article 14, and not a direction simply amendment is amendment to the rule, really the consequential action. This is not the observation and nothing else. The court has made it clear that we are not supposed to give any direction to amend the rules, but for the purpose of this protecting a right of a citizen, if amendment is required, it is required.
Lordship will take not just one line at paragraph 22, Lordship,
Yes.
last two lines.
Yes,
Last two line, Lordship, page 26, Lordship, paragraph 22.
yes.
Steps implementing the recommendation of the 7th Pay and Productivity Pay Commission as approved by the State Cabinet by carrying out necessary amendments to the rules of 1963 so as to integrate the post of DO.
So if
With the
without amending the rules, you can carry out the direction, carry out.
That is the difficulty, Lordship.
That is the difficulty. You can't do that.
And the post held by the
And you are
petitioner
not agreeing to.
is a
amending the
temporary
rules,
ex-cadet
then-
post, Lordship. The post held by the petitioner, Lordship,
No.
is a temporary ex-cadet post, Lordship.
Mr. Nayak, please don't forget, we are following a Westminster model here.
Lordship.
Cabinet decision, your bureaucracy, your department is sitting in appeal over cabinet decision. These are not good signs.
Lordship.
All the court has said is that the cabinet decision and the pay commission recommendation, which is categorically held, that this is a clear case of anomaly. And your GAD department has also agreed with it. After that, the administrative department does not agree. What is his fault? He is serving in the same post, same process, everything is same. Just that the post is not mentioned in the rules. So you will not give him anything, and others who are similarly situated will go on getting all benefits.
And for merger, my lord, it's one stroke of a pen. In other departments, so many mergers, merger of posts, my lord, integration of posts. The rules are amendment of the rules, perhaps. This is a futile objection.
The request of the learning council for the respondent is this matter on 27th of March.
Give them one final opportunity to comply.
27th of March to enable the contemners to comply the order passed by this court. Just on 27th of March.
May I pray for in the first week of April, Lord? Because 23, 24, 25, 26 are holidays. First week of April, Lord.
Third April.
We'll get some
Why?
time. We'll get some time, Lord.
2 weeks, you have sought for 2 weeks time, 2 weeks is there already.
Yes, it's 4th March today.
I'm praying for 2 weeks from the week starting from 18, Lord.
Yeah, how can you?
First week of April, Lord. 1 week.
4th of April.
Lordship. Oblige, Lord.
4th of April. To enable the-
No, perhaps, my lord, one of the contemner, he'll retire. That's why this prayer has been made, my lord. One of the contemner, chief secretary will retire,
Will take care of
perhaps.
it.
That is the reason why,
The new secretary will.
that is the reason a prayer has been made.
Mr. Nayak, the system operates on a sense of mutual respect.
Lord.
Please tell your officers, these kind of
force
tactics,
us.
we know how to deal with it, and we will.
Don't force us to.
Lordship.
Item 41.
Oblige, Lord.
Deeply.
It would be embarrassing then.
But this contempt appeal, Lordship has directed to list along with the review petition, my lord. My lord, the review petition is not before your Lordship, my lord, today, my lord. 6 of 2024. Last order, my lord. On 8 to 24.
We only the big hit. How did but the order is not helping you what it in experience. Punishment area, you said. Content is drawn against. Punishment to be. But yeah, it's maintainable against that type of punishment. Look at recording it. Otherwise, there is no constitution for the punishment.
এটা প্রয়োগ করছেন এটা প্রয়োগ তাহলে কোন প্রয়োগ করছেন ঠিক ঠিক
So there is no observation of conviction of the appellant, is it?
Yes.
But
Without conviction, proposed penalty is being,
the conviction, yes, as regard the sentence, yes, the learned single judge has kept the matter. Otherwise,
no, what we find is contempt proceeding is initiated.
yes, my lord.
After that, on hearing the contemner, court has to arrive at a finding that he should be convicted.
In
Then
fact,
the question of penalty.
but here, my lord, in fact, the finding has been recorded that he has committed contempt. He has the contemptor has committed contempt. That finding has been recorded, my lord. But
There are 16 and 17 of the 18 order.
para 15, 16 and 17, 15 also, my lord, this stand in the last sentence, my lord, this stand in the considered opinion of this court cannot be said to be a case of non-willful and non-deliberate violation of this court's order. The unconditional apology sought for, therefore, in the given facts of the case and in the backdrop of the conduct of the petitioner is rejected. Having the aforesaid satisfaction, contempt is drawn against the respondent for willfully and deliberately violating the order dated 17/2/2023.
Argue your review petition.
Well, let the review come along. The review has not been listed today. It is not listed. It is not listed. Lordship was directed to list the review petition.
Item 41.
6 of 24.
Item number 41 is review is listed, sir.
Huh? It is.
Okay. Fixed with the writ appeal number,
42,
not review.
not review. Lord. So writ appeal 42 has been shown.
This contempt application along with writ appeal number 42/2023 decided 42/2023.
Along with review,
6 of 24, my lord, review petition number
Along
6
with the review petition number 6 of 2024 on twelfth of March. 12th of March.
Item 42.
Made physical lordship. Lordship, may kindly adjourn the matter for today, lordship.
Last time you were supposed to take some instructions. Now in 2024, the order has already been placed. On that day, senior counsel asked that I'll complete the instructions. That was the only.
Lordship.
What remains now in this?
Lordship, the only issue is that I'm not able to get through the instructions. He's on his way back. He was out of station, lordship.
Who?
My senior, lordship.
Pass over for the day.
Lordship, could it be day after tomorrow?
Pass over for the day.
Lordship, much obliged.
Lordship, in item 41, Lord, I'm sorry, my lord. In item 41, there is a stay, my lord, that may continue. Oh, Lord. Continue.
Item 43.
It is 7. Affidavit, my lord, on their part is awaited. Affidavit on behalf of the finance and education, yet to be filed.
Yes.
On behalf of the finance department, we are filing the affidavit today. It is ready.
Mr. Pujari had submitted that reply on behalf of the counter affidavit on behalf of the finance department would be filed during the course of the day.
My lord.
Full stop. Copy of the advanced copy of the affidavit be supplied to the counsel for the petitioner. List this matter on 4th of April.
Obliged.
I'm so obliged.
Item 32 to 34 for hearing.
Please, my lords. Lordship, the respondent government has already submitted their version. Now today.
I have not submitted completely, but you can continue after that.
Okay, then carry on. Complete your submission.
Yes. Yes, last hearing, my lord, there was a small confusion as to whether the appointment can be only by ad hoc or also by direct. And they pointed out the particular marking in the advertisement, which says it can be by either. We were at that stage last time. So lordship were to see the advertisement.
That's at page 56. My lord has got that one. Paper advertisement.
Yes.
Right at the top. I'll just read the 4 lines. Advertised number such and such. With reference to the government office memorandum, applications are invited for filling up the following vacancies held by ad hoc appointees. So therefore, there was a confusion whether it meant only for ad hoc or also for individuals. Right at the bottom, I think in the note, we have it that it can be for either of them. Yeah, at 4, my lord, right at the bottom, note 4.
Yes.
All the candidates, bracket ad hoc oblique fresh. So which means they could also apply. So that doubt has been clarified. So in this connection, I wanted to make a very brief clarification, going by their petition. My lord may kindly see the writ petition at page writ petition is from page 42 to 54. Relevant page is page 48, madam. My lord has got 48, my lord.
Yes.
Para 4.
Internal page of the internal page.
I have this internal page 5 of the writ petition. And according to our marking, it is running page 48. Para is para 4.
Correct.
That's not correct. It's not telling.
My lord has not got it.
Doesn't tell you. There's some error in the page.
I am talking of this appeal, my lord.
81.
81 of 2033. We were going through that. I'm sorry, madam. 81. I'm sorry, madam. Last time we were on that petition.
Yes.
80.
Also on that.
Okay. I'm sorry, madam. I was thinking it's the same thing. Page 48. My lord has got that.
Yes.
May I read it, my lord? That for whatever reason, the aforesaid result never materialized. They're talking of the 2004 interview. That never materialized. And after 2 years, the petitioners were issued another call letter bearing such and such, dated 19th July 2006 for screening test on 21st July 2006. While the DSC conducted a screening test for regularization of ad hoc grade 4 employees, petitioners were interviewed and once again recommended for appointment to the post of such and such. The result was forwarded to the chairman and the details are made in annexure D, E, and F. Now I'll come directly to D, E, and F. Kindly see page 66, madam. I would just clarify before I read it. Their claim is on 2 results. One is of 2004, which they say did not materialize. The other one is in 2006, which they have mentioned, which they say had materialized. Kindly see now, page 66. Address to one of the petitioners. You are asked to be present at the screening test for regularization of service on 21st July 2006 at the office of the chamber of the undersigned at such and such time. So they have been asked to attend the interview for regularization because that particular interview was only for regularization of ad hoc employees, which took place in 2006. Now, my lord, you are to bring your appointment order along with your educational certificates, which means they are already appointed, they are ad hoc, and they are going to be regularized. Now, my lord, kindly see the next page at page 69 in support of this. My lord, is page 69?
Yes.
Right. Only one paragraph. Top, result of screening test for regularization of ad hoc appointees of grade 4 employees. Below that, this is reference to your such and such dated 13 December regarding conduct of screening test for regularization of service of ad hoc appointees of grade 4 employees. So again, what they're relying upon is those who are already on ad hoc, but for regularization. I'm going to clarify it further in the next page, page 70. In the middle, my lord, after 1, 2, 3, 4, names of the selected employees for regularization of service. My lord has got that, my lord. Now, these persons are mentioned here, like in 3, such and such. So, I just pause here for a moment, my lord. Since there was a confusion as to how they have been interviewed, forget the 2004, they are entitled to interview, no comments on that. I stand corrected also. No, as far as this is concerned, this is purely for those who have been ad hoc and who were supposed to be regularized. So when this question came, we have answered these paragraphs in a counter affidavit in just one paragraph. Kindly permit me to read it. The counter affidavit at page 90.
Yes.
Well, para 3 speaks of the interview of 2003, but I'll just read it, just few lines. Statement made in para 1, 2, 3 of the writ petitions admitted to the action bound by records. The advertisement dated 7 July clearly stipulates that vacancies at 4, 5, 6, and 7 is for candidates holding diploma in ITI, and preference will be given to landowners in respect of vacancies at item number 8, 9, 10, 11, 12, and 13, subject to careful scrutiny of the selection committee. The petitioner is silent as to whether petitioner number 2 and 3 had diploma in ITI and as to whether all the 3 petitioners are landowners. Now come to the relevant paragraph, para 4. This is regarding that ad hoc. That in regard to the statements made in para 4, 5, and 6 of the writ petition, the defendant states that the screening test was meant only for regularization of grade 4 employees who were in ad hoc service and not for fresh appointments. The call letter dated 19 July and the letter dated 25th July itself mentions about regularization of ad hoc employees. The district selection board therefore erroneously conducted the screening test for the petitioners who had applied for fresh appointments. However, in order to properly ascertain the nature of the petitioner's recommendations to the post, next page, the Director of School Education by letter dated 22nd April 2013 asked the District Education Officer Dimapur to clarify the position on the matter and to submit the same at the earliest. In reply to the letter dated 22nd April, the District Education Officer Dimapur, while recommending the appointment of the petitioners, has clearly mentioned how they do it. This was at the request of the candidates, that is the petitioners. So this, not by any government authority, they said, okay, come, you join us. They were interviewed along with the ad hoc appointees. Now the answer. The deponent states, since the direction for conducting the screening test was meant only for regularization of ad hoc appointees, department did not act on the recommended screening committee. So now here it is very clear. What they are talking about 2006, which refers to ad hoc, they are trying to say that I didn't get it in 2004. I was again selected in 2006, and again I have been rejected. Now, my lord, your lordship were to see for a moment, the yeah, the judgment for a minute, madam. Try this.
Judgment?
The impugned judgment, which is there. That is at page 103, madam. I just clarified it. Para 10, madam. I read.
You are assailing the judgment dated 24/2/2021.
No, this is actually the original writ. The other orders are when we ask for extension of time from time to time. So they give us 2 weeks, 4 weeks, 6 weeks.
No, no, what is the original judgment which is under challenge here?
Pardon? Yeah.
That is 6/8/2019.
Correct, man. 6/8/2019. That is only page which I am referring to, 103. No, para 10, man. That's at page 108. My lord has got that.
Yes.
Please. Although it may be open for the state respondents to adopt any criteria of selection for the purpose of appointment of grade 4, yet in the considered view of the government, once the advertisement is issued for selection of grade 4, whatever may be the criteria, yet in all fairness, it is imperative the selection made in the pursuance be published. Now, although there may be substance in the contention of the state council that the petitioner has not been vigilant about their rights, and there is considerable delay in approaching the court, yet in view of the decision rendered by the court on 29th April 2015 in writ petition such and such, along with connected writ petitions where it had directed the respondent authorities to declare the results of the recruitment held in pursuance of the advertisement dated 7th July, I also deem it appropriate to allow these writ petitions by passing a similar direction that has been passed in writ petition number 107K of 2013. So the court is saying in a similar petition, there was a direction passed for these people who have gone through this process. So I am only passing, I'm only following that judgment. That judgment, my lord, on page 74, only 2 pages, 74 to 76.
Yes.
Only the last. After considering the submissions made by the learned counsel for the parties and under consideration of the materials available on record, the court is of the considered opinion that litigation concerning the post of UGTs has got nothing to do with the present petitioner. However, surprisingly, respondents are yet to publish the result of the petitioners and so far as to the post which they have applied is concerned. Respondents are directed to forthwith take steps to publish it. So therefore, in 2015, on the similar advertisement, there was a clear direction that you must publish these results. Now, I have also mentioned to your lordships that there are series of notifications by which the class 4 ad hoc employees, they were catering only to those who were landowners. Now, in response to this, we declared the results of the other group, grade 3. And our declaration is on the next page. Kindly see page 77. So we are given all the details.
That writ petition of 2015 was in relation to other posts and not the post on which the petitioners have applied.
No, I'm just a minute. Last time I had given this. This is actually a typed copy of what is there on the next page at page 78. Same thing. 78, it's not very clear.
In compliance of the court's order.
Yes, I will just read it. In compliance of the Honorable Court Order dated 25, it is hereby notified that the advertised number such and such interview results of successful candidates of grade 3 and other category of teachers have been declared in the Directorate of School Education Notice Board. The successful candidates are directed to produce the admit card before the legal conference, etc. It is further notified that in accordance with the department notification order dated such and such, the grade 4 posts were being directly appointed from landowners, hence appointments will not be based on the interview results. So this was there in 2015. This has become final. There was wide publication in various newspapers on this, and now we are here after 8 years. That is final. Now, when the Honorable Court said that we will follow what is there in the earlier judgment, of course, it is mentioned declare the results, but since it was not possible because this was given to landowners, this is the clarification. So even if you're going by the landowners thing, we could not do this for them at this stage. Now, my lord, my other only point is that whether we have the, and I have also mentioned to your lordship that we don't keep the records graded as C beyond 5 years. That's right at the, just to refresh your memory, I will show the page number. Kindly see, my lord. I think it is on page 167.
Yes.
Please. This is called maintenance of records delineating the responsibilities of the state archives, record cell, and individual departments. Now, I come straight to the classifications. Classification of records. Normally, records are classified into 3 categories, class A, B, C. Documents may be recorded under any of these classes as indicated below. Class A means any document file having historical value, importance, and that may be required for frequent reference. These categories of files, documents are to be scanned and preserved for indefinitely. The original of all these categories should be preserved. This A category of file documents are to be reviewed every 25 years. This category A. Now B. Class B means file documents which contain orders and instructions having no permanent importance and are not likely to be required for reference for after 10-12 years. The category shall be for 12 years. Class C means file documents of secondary importance which may be preserved for a limited period. This category of files documents shall be preserved for a minimum of 5 years and not more than 10 years. Now, to which category does these documents belong is on page 169. My lord is what 150. My lord is what 160. I am directed to refer to a letter on the subject stated above and to state that the documents referred to in a letter may be categorized under class C as per the classification of court documents and such and such. This has the approval of the Principal Secretary, CNR Department. Therefore, my lord, when we say maybe we have some record, we don't have any records, mostly they are kept for a particular period. And in this case, the obligation to keep it was only for 5 years. Now, what is it they are asking, my lord? For a moment, let us come back to this petition. Whatever took place, 2004 or 2003 took place. Let us take it that something took place in 2006, rightly or wrongly. A petition was filed on the same advertisement in 2013. That is the judgment which I just read out 2-3 pages. There the court said, you declare the results in 2015. When the publication came in the newspaper that this is only for landowners, after that, in 2016, there were fence sitters till then waiting for the outcome of the petition. And immediately after they saw that they are not going to get it, without giving any explanation as to why they didn't come from 2004 to 2016, they quietly filed the writ petition. Now, writ petition of this nature, my lord, though limitation is not mentioned, it loses its significance because it is deemed to have expired. They don't have any vested right. Why so, my lord? In this period of 10 years, those who were selected in 2004, you can't unseat them. There's no vacancy. Now we are in 2024. I'm just going slightly deviating into the merit. So if we go and see now, they want to be appointed to that post on the basis of the 2004 interview. So now 20 years have lapsed.
Yes.
No, if your lordship want to see, I've given a series of judgment your lordship is aware as far as the delay is concerned. I'll just point to one or two, page 19. All of them are on this point, 19. Right at the bottom, my lord.
Page?
Page 19, running page, that is
One line
of our appeal.
Your appeal.
Why the 3 appeals, Mr. Balgobin? Why 3 appeals? Why 3 writ
Because
appeals?
there are three parties.
3 parties.
One was the peon, and am I right? One was the
Yes.
carpenter, and the other was the
Knitting helper.
knitting. Same issue. Everything is the same. Word to word, it is the same.
3, they did not file in 3 writ petitions. They say that this case will cover them. They file only 3 writ appeals. Till revision, there were 6 cases, lordship, but 3 they did not file.
What happened in those 3?
They are just lying like this. What they told the petitioners is that if this writ appeal is allowed, they will be covered. They did not file in another 3 writ appeal. They did not file.
That is up to them.
Yes.
That's true. Vacancy, page 19, right at the bottom. In Rubemans versus Union of India, petitioners are re-agitating against claims which they had not pursued for several years. Petitioners were not vigilant, but were content to be dormant and chose to sit on the fence till somebody else's case came to be decided. The case cannot be considered on the analogy of one where a law has been declared unconstitutional and void by the contract so as to enable persons to recover monies paid under the compulsion of letters or retire. There is also an unexplained inordinate delay in preferring this writ petition, which is brought up after almost a year. Our case is after 10 years and 12 years. Like this, my lord, so many of them. Next page, my lord, page 20, bottom E. I'm just reading the 3-4 lines. I have the judgment already.
Please supply the judgments you read now.
Please.
Supply the judgments.
Right.
Copy of the judgments, you supply the copy of the judgments.
I'll supply, madam. I'll supply.
Yes, now read.
Will read. The matter requires examination from another aspect, namely lashes and delay. It's a very recognized principle of jurisprudence. The right not exercised for a long time is non-existent, even when there is no limitation prescribed. Now, page 22, what she was referring to, that is covered by this. That's why I'm reading out. Page 22, Bharat Sanchar Nigam Limited, in the middle, my lord, versus Ghanshyamdar. Para 26. On the other hand, where only the affected parties approach the court and relief is given to those parties, the fence-sitters who did not approach the court cannot claim that such a relief should have been extended to them, thereby upsetting or interfering with the rights which have accrued to others. This is what I was saying. This is of 2004, 2006, they've been appointed. Now they want to get into it right now. Then, my lord, at page 223, para 11, I'm not reading it, I'll just explain to your lordship. This is only to say that we have the policy of giving these jobs to the landowners. They admittedly were not landowners. Our policy has not been challenged by them at any stage. The policy itself stood the ground from 1972 to 2018. And we withdrew it in 2018. And till then, all these landowners were giving abundant land to the government, almost free of cost. So as a concession, since they did such a big thing by which we could bring up institutions, this small concession was given only for that purpose. It was not free.
They filed writ petitions in exactly in which month?
2016 they filed. The writ petition we are discussing about today, July 2016.
All three petitions?
Please, my lord. And all the earlier petitions which were there in this case, which we were discussing about, just 1 minute, please. Yes. You can always read it. 2013 is the time when the earlier petition was filed.
Wherein the orders were passed.
Yes, in 2015. That is which I read out those 3 pages. Orders were passed in that. That was sought to be followed here. Then the publication came and this is it. So they're very prayer in the petition, my lord. Kind of have a look at it. The prayer is at 54. What do they want? Yeah, 53, 54. Direct the respondents, declare the advertisement. Operative portion is at 54. Appoint the petitioner number 1 to the post of fuel, to the post of carpenter, and to the post of helper, as per district selection recommendation dated 2nd March 2004 and 21st July 2006. So they want an appointment after 12 years. This is the basic thing, not about the declaration, not an academic formality. They want the appointment. And the appointment, they're asking in 2016 of an admitted selection, rightly or wrongly held, in 2004 and 2006. They are not entitled to this relief at this stage on a plethora of judgments which say that if they've been sleeping over their rights, if they are fence sitters, if they're waiting for the outcome, then they cannot interfere. This is my humble submission. Word I'll explain. Grateful to you, Lordship.
Wait, please, my lordships. Lordships, before going into the merit of the case, this is my case, and I just humbly pray that my lordship will have a short patient hearing on of my case. Here, lordship will kindly appreciate that. Let the learned AG place before this honorable court that when examination is conducted, it is they who did not declare the result, and some of the candidates approached in 2015. Is it the duty of the petitioners, the candidates, to each and every candidate to approach the court and get an order for declaration of result? Who declares the result, lordship? Show the law. Show the law that after appearing examination, the candidate has to approach the court, and for declaration of result, they have to bring the judgment order of the court. Show the law, show the law. That is one. Now, lordship, what has happened is they have sought time three times.
Please remove me. Why are you so angry?
Lordship,
You're angry on who?
I beg your pardon, lordship. But just hearing the absurd submission is also sometimes, I beg your pardon, if my lord, I'm still like this, but it's absurd. That is one question of law. Now, when the law, this is a judgment in rem, not in personam. So do the candidates, all the candidates have to approach this honorable court? This is judgment in rem. They should know it. They are the state, lordship. So this is one aspect where it is not in personam. This is judgment in rem. And lordship, the law is very clear. The law is very clear in 2015, one Supreme Court case, SEC 347, page, paragraph 22 and 22(1). Twenty-two, 22(1).
This judgment itself says it's a judgment in personam. The judgment of, at page 76, they say this is for the petitioners before the court. Page 76, they clarify.
Yes.
22, lordship, paragraph 22. The legal principle which emerges from the reading of the aforesaid judgments cited both by the appellants as well as the respondent can be summed up as under 22(1). The normal rule is that when a particular set of employees is given relief by the court, all other identically situated person needs to be treated alike by extending that benefit. Not doing so would amount to discrimination and will be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. So that will cover my case, lordship. Then my lord will kindly, they are going against their own advertisement. The advertisement says preference will be given to landowners. It is a general advertisement, and in the advertisement itself, it says in one, my lord can kindly refer to page 56. The last item number, the last line in the middle, item number 8, 9, 10, 11, 12, and 13. Preference will be given to landowners subject to careful scrutiny by the district selection board. This is already done, lordship. This is 20 years back. They are coming back and going to square one, saying that challenging and this advertisement. It is their own advertisement. District Selection Board is legally constituted in all the districts in Nagaland to recruit grade 4 employees, Lordship. Now, what is the use of this advertisement if 20 years back they're coming now and from back to square one they're asking? Anyway, I have to substantiate that, Lordship. Now the learned AG has submitted that we did not possess the a certificate, diploma certificate. Here is the diploma certificate. These are all done previously by the District Selection Board, Lordship. 20 years now, why? I don't know why.
So
they
have you produced the diploma certificate at the time of your
Yes,
selection?
yes, because my lord will kindly see. When the advertisement say that diploma certificate should be there, why they are questioning only now? Because not only us, but all the candidates, they were verified with their original documents, land owner certificate. And my lord, one aspect is that in Nagaland, since 1984, land owner scheme has been adopted by the state government, especially in this school education department. So by now, all the landowners have been appointed prior to that, Lordship. And now and landowner appointment is only one time. The state government has adopted one-time appointment. So since 1984, landowners have already been appointed. Those some are still coming to court. Those who have oral agreement at present in Nagaland. Now, all these were placed before the District Selection Board. The condition itself says landowners' preference will be given to landowners. It is a general advertisement, but this is being said. And also at 14 also it says, selection of candidates will be purely on merit basis except for candidates under item number 8, 9, 10, 11, 12, and 13, for which preferences will be given to landowners subject to the recommendation of the District Selection Committee. So all these things we are done. Now we are just asking for declaration of result, and how can it go back to this? Nevertheless, here is the proof in evidence that the two petitioners, appellants, respondents, petitioner have their certificate.
They have not filed it. We have objected even in our counter that they have not replied to that. Para 4 of our counter.
Yes, please.
Those are the certificates that was submitted before the.
It's not giving call.
That was afterwards of the counter. Now. It was in. Two of the petitioners are landowners. It also was placed before the District Selection Board.
These certificates are of which date?
Lordship.
We want to know that there is no contact.
5/2/2001 to 5/2/2002.
The certificate dated, certificate of proficiency,
That 13/3/2002, Lordship.
13/10/2002.
13/3/2002. One is Kievi Sema.
All the dates same day.
5/2/2002. Then one is 30/10/2002. These are all prior to the.
You give us copy.
Yes.
These are different. You have given to the regular set, regular document.
Lordship. One is for the petitioner number, appellant, respondent number 2. Is this the one?
This is in relation to two persons.
Two persons, because only these two persons need the
You
certificate.
applied for that, na?
Yes, logic. The other one is peon. They don't need any certificate, logic. And with regard to land owners also, I have the previous ones. One is general category, at respondent number 2 is general category, and landowners, we are placing 2 for the respondent number 1 and respondent number 3.
Please give us call.
Yes, yes. They are not like everything. So these are all, I just want to substantiate before this honorable court that all this were already done in 2003 by the district selection board. Now, why are they going back after approaching this honorable court twice? They say that they are going to implement the judgment order and they took time two times by filing an IA.
What will be the age of the petitioners now?
38 to 45. At that time, even if presuming that they are 18 years lordship, by now it's already 38 or 37.
By presuming, or what was the actual date?
No, actually, they may be at that time when they when they file it, they may have the age must have varied.
Don't you have any proof regarding their age?
Lordship.
The proof regarding their age at the time of
One is
applying.
at the time of filing in 2000.
In 2016, they were 40 years, according to their affidavit.
Yes, to my
So
affidavit. in
that means today,
47.
48 or so, and this landowner certificate is not a certificate that stating that they are landowners. It's a suspicious document. See the print of the date, very bold, different from the others. The date which has been issued. Even this does not affirm they are landowners. And none of them have been filed before the court at any stage.
Lordship, that is already a settled matter in 2003.
Yeah.
Now we are just seeking for declaration of our result because we have the place before this honorable court, the district selection board recommendation for us.
So supposing the results, assuming that it is declared,
Lordship,
what, and your client's name appear in the list,
Lordship,
then what will happen?
they have to be appointed as
Appointed against which vacancies?
peon, one is peon, one is
Vacancies
meeting
which
helper,
were advertised in 2004.
carpenter
Those
helper.
vacancies are still lying according to you.
Lordship, till the time when we approach the court, the the DIS, that is District Inspector of Schools, says that it is still lying vacant, and that since we are pursuing this post, they have not filed. And Lordship, they are saying that this is a landowner post, but I also have this before this honorable court. At the time when this case was going on, the respondent pleaded before this honorable court that it is a landowner post. So the respondent were directed to bring the appointment orders of those landowners, and this is the only appointment orders they could place before this honorable court. And these are all appointed prior to 2003.
No such direction in this case, my lord.
I placed this before this honorable court
Maybe
because
another case.
in other case, they were
Other
same case.
We are in a
They
separate
were
case.
directed to bring the appointment orders they have already appointed, and these are in the same advertisement.
Yeah.
So we filed this even in the previous cases.
You kindly
This-
find the order also, which case? Order passed by court.
So these are the. It may not be, but it is in general. They submitted before this honorable court, it is a landowner post, but when they were directed to place it before this honorable court, they could produce only this. And all those appointments are prior to 2013, 2003, Lordship. This way they are trying to deny us, and approaching this honorable court for declaration of result is that illegal, Lordships. Technicalities, they are submitting so much to confuse this honorable court. Now, Lordship, kindly come to the first writ petition here. They in their review, in their IA application, they have prayed before this
If you
honorable
want to
court.
rely on these documents, then you have to file it through an affidavit. Otherwise, we
What
cannot.
is the relevance of these documents?
And this is another case, not this case.
No, what is the relevance of these documents?
I want to pray before this honorable court that there is no landowner appointment. Only these are appointed prior to 2003. After this, yes, Lordship.
Another thing
Lordship.
that we are not concerned.
Lordship,
Please come to facts of this case.
Lordship.
They may or they may not have appointed. We are not concerned.
Lordship.
And so far as regarding what these qualification certificates you are placing reliance, these are not on the part of the writ petition, sir. Madam,
At that particular time, when we filed this, Lordship, particular time, since all these have already been done by the district selection board that is legally constituted.
once, even in your counter to the reply, you have not filed these documents. Now, for the first time, you are across the table, you are forwarding.
One is already filed, Lordship. A sample I have annexed and page 88. That was in the writ petition, Lordship.
Page
88. Yes, only that.
80.
88, Lordship, page 88. 88. This is
They don't say it's the landowner, even in this.
NOC
Lordship.
to certify village council, landowner.
No, village.
Landowner
Yes, Lordship.
has no objection against the appointment of so and so, beyond grade so and so. NOC being, it is one of the petitioner.
Yes, Lordship. Respondent number 1 now.
Why they sought this no objection certificate?
Because here in Nagaland, the practice is that the village council issues no objection certificate to the landowners. Otherwise, to go place before this honorable court, the village council in Nagaland.
We'll resume hearing after.
Lordship.
The village council has no object, sorry.
I'll just convince my lordship that the 74 is the order that
Even the landowner certificate, which he gave me a copy, that is landowner is the village council, not the petitioner. They said we have no objection, though your lordship is not taking cognizance of it, but they should not just file applications.
in Nagaland, the village council issue landowner certificate to those deserving either personal land ownership or village land jurisdiction. So that has no issue, lordship. That is the practice in Nagaland, lordship. And the learned AG knows it very well because he is the AG of Nagaland, lordship. Now, here, my lord will kindly see that it is they who filed the IS extension of three times since 2015, and for revision, they 400 and something days. They pleaded before this honorable court, and it was they who were seeking time before this honorable court, and suddenly new ground they are bringing, that delay and laches. Where is our delay and laches? When they did not declare result for 8 years, and in 2015, the grade 4 also approached this honorable court, and this is the basis. So 74, the first writ petition 107 is drawing post from Gokchung. second one, writ petition civil number 140K 2012 is carpenter helper from Dimapur, one of the candidates, Lordship, carpenter helper. So therefore are also in this writ petition. Then writ petition 139K 2012 is knitting helper. That is the present two posts. They also approached this honorable court. Knitting helper and carpenter helper are before this honorable court, Lordship, if my lord has already seen. Then writ petition 141 is carpenter instructor. That is class 3 gazetted and their result has been declared. Then writ petition 92K 2013. That is also carpenter helper. So carpenter helper in one writ petition in same advertisement in same selection board recommendation, they left out. Now what has happened is my lord will kindly come to I will just satisfy my lordship that judgment and order 6/8/2009. It was to be published within 2 months. The direction was given by the honorable court. And since it is a only publication of result, that's why it was, as my lord, law applies in general. And after they publish only the teachers and this class grade 3 employees, we submitted our representation in 2015, we submitted our representation, that is at
Page 79.
My lord is very conversant, lordship. 17. Yes. This is the representation that we have submitted. I have annexed 2 representation, and this is the submission. Then my lord also will kindly come to 58, annexed 58, page 58. This is the first calling letter. I don't know, till that I have also confirmed they have never been appointed. We don't know why they issued that for regularization. That calling letter was issued, and we are nobody, just a candidate to question the respondent for issuing, calling us as regularization. But till that, I pray before this honorable court that we have never been appointed, but that calling letter for regularization was issued in the second 2005 calling letter. There were 2 calling letters were issued in
2006.
Yes. So the first is at page 58.
Yes.
So this is just, there is no such kind of, the first calling letter, there is no such kind of regularization or whatever. This is the first calling letter, and this is the basis. The 3 respondent petitioners are here. 58, 59, 60. This was issued in the first calling letter. This is the main basis. 2003 advertisement. And this is as for the whole district. It is not only Dimapur district, but my lords, it was fixed in between the same month, and all district in Nagaland held the district selection board, though the dates varies. Then I would also like to bring my lordships to a very important aspect. Yes. My lord will kindly come to page 61. This is the recommendation of the committee. They are none other than the DC of a district, DEO secretary, board members, DIS, assistant director, board member, that is from the department itself, lordship, and DEO board member. From the department itself, they send the board members along with district deputy commissioner. They were the recruitment board, district recruitment board. Now what has happened is, I just want to disprove what the respondent government has submitted before this honorable court, trying to confuse or mislead this honorable court, lordship. Now my lord will kindly see page 64. These are the recommendations. These are linguistic teachers. Then 65 is science stream. 65, if my lord has seen. Page 65.
Yes.
Yes, then my lord will kindly see the three respondents. Carpenter helper at the third bottom, lordship. The first is carpenter instructor. The second is knitting instructor. The district selection board selected and recommended. Then the third one is carpenter helper. That is the respondent number 2. Then knitting helper. That is the respondent number 3, prison respondent petitioners. Then the last one is peon, the respondent number 1 in the prison writ appeal. Yes, even in all human probability, lordship. This is the declaration of this is the recommendation of the district selection board. It is in the same page along with other categories that were recommended, lordship. How can the respondent government submit before this honorable court that these pages have gone missing and they have thrown it to the dustbin or they have destroyed? Isn't that misleading this honorable court? Lordship. In the same, they declared in 2015, these other categories, 2015, they had the records. Now suddenly they come before this honorable bringing some PAR notification or whatever, and within this kind of recommendation letter, they submit before this honorable court. We have the right to destroy it within 5 years. Is that a submission, lordship? Is that a welfare state? Is that legally perceivable? There is fishy behind the scene, lordship. So in all the other, it was on the same day, it was conducted. The recommendation were in the same paper in continuation. How could only they bring before the honorable court that the documents is already destroyed by a respondent government? This is 2015 in the same. This is something very, that is what is a bit agitating as well as. And lordship will kindly, I'll just read out what they submitted in the writ petition. This is writ petition 12. What is it, 29 or 15? 29. Submission of my lord will kindly come in here what the respondent government council submitted before this honorable court here. The page number 76, just for my.
इसमें सेमाफोर यहाँ पे सुई दिया है। ये खेलिए सुई। The names don't match. Sir. The names are not matching. ये तो 2004 का होता है। इतने 2004 एडवर्टाइजमेंट में वही लिखा है।
Well, this letter, this page 71 annexure G.
Yes, Lordship. This is again another that was issued by, that was second time.
Second time you just read the language of this letter. With the reference to your letter, so and so interview was conducted following procedures and norms, but it was reported that candidates and insisting submit their appointment which they have yet not received. Page 71,
71, Lordship.
annexure G.
Where they say it was cancelled. They have mentioned where this was cancelled.
That they were duly interviewed and selected by the district selection board held on Itna. But it was reported that some district had complained about their interview in their district. Unfortunately, the said interview was cancelled for the whole state and they have been denied appointment with no fault of them.
Yes.
So when these interviews were cancelled,
No, Lordship, that was referring to previous one.
of 2004.
2006. 2004.
Yes.
Then as per direction of the authority, the interview was held on 21 July 2006 and selected them for appointment.
No, we are just trying to convince ourselves that you are referring to this, this result or the convey of result or whatever this of 9/3/2004.
Yes, Lordship.
Annexure C.
Yes, this is.
That your interviews were held on 9/3/2004 and thereafter they have prepared this list of the selected candidates. That is as page 64 and your name appeared in 65.
Lordship. Then
Now,
next to that, next to that, if my lord will kindly come to page 72. 72. That is clarification.
listen. Now, this letter of this 7th of September or something, 28th of September 2006 says that those interviews were cancelled. And thereafter again, new interviews were conducted.
Yes, Lordship. So this is the deputy.
Now your prayer for granting relief on the basis of this 9/3/2004, which interviews have already been cancelled.
Then, Lordship, 2004. This is
They
the
have
second.
admitted this in para 4. It did not materialize.
It did not materialize, Lordship. So the second one is conducted on 21st July 2006. And this is the second one, page
Second one is
69.
Regularization.
69, Lordship.
Second one speaks about regularization.
But that is what they have stated, but I have till that, Lordship, not even once has the three respondents have been appointed, Lordship. If my lord will, lordships will.
Direction related to public.
A reading of page 73 will clarify.
This is based on 2004. Itself was cancelled. Yes.
Lordship, page 73 will clarify. My lordship will be satisfied with this clarification. This was issued on 4th September 2013, where the district education officer, that is the district highest education department in the district authority, where my lord, the confusion, this is the clarification, lordship 73. Allow me to read out, my lord.
Yes.
Submission of clarification. This is to the principal director who sought the clarification as to what is the status of the vacancy. So this is the clarification submitted by the district education officer Dimapur to the principal director of the school education. Submission of clarification for conduct of interview on 21/7/2006 for grade 4 under Dimapur district. Sir, with reference to your letter number so and so dated the 22nd April 2013, I have the honor to submit here with the detailed report regarding interview that, sir, candidate EAV as carpentry helper at GMS Sovima, V. Yakheli as knitting helper at GMS Kushabil, then 3. Ihoshe Pion at GHS Akahuto. They have appeared interview in the year 2004 and declared passed copy-wise. But said result was cancelled, reason known by the government. To the request of the candidate, they were again interviewed along with the ad hoc appointees under the chairmanship of Deputy Commissioner Dimapur. At these two, they have declared pass copy enclosed, but they were denied to give appointment order without any reason. Since they duly passed both the interview conducted by the district interview board, the posts are still lying vacant. Therefore, I request the authority to kindly look into the matter and consider their genuine case and issue the appointment order as per recommendation of the interview board. Your kind early actions on the matter is highly solicited. I humbly pray that my sir can kindly bear with me and let me.
It's only this one line, maybe she advertently missed out in the paragraph is, they've appeared in the year 2004 and declared pass copy with the said result known by the government at the request of the candidate. So it is that has to come on record.
So in 76, the learned page 76, the middle portion to the last up, lordship. Miss S. Mary, learned government advocate, has no objection if such a direction is given to the state respondent to publish the result of different categories of posts in which the petitioners have applied, inasmuch as the litigation that have taken place has got nothing to do with the present petitioners before this honorable court. After considering the submission made by the learned counsel for the parties on the consideration of the materials available on the record, this court is of the considered opinion that litigation concerning the post of UGTs has got nothing to do with the present petitioners. However, surprisingly, the respondents are yet to publish the result of the petitioners insofar as the post to which they have applied is concerned. The respondents are therefore directed to forthwith take steps to publish the result of different categories of posts to which the petitioners have applied and thereafter make appointments to the selected candidates. Such steps should be completed as early as possible and not later than 2 months from today. With the above direction, these writ petitions are allowed. Lordship, this is the finality. Now coming to page 78, by what authority the respondent government in 12 years, they did not even issue a corrigendum, the legal process. They did not even issue a corrigendum, and under what authority, what source of law they would appoint, they could violate in violation of the advertisement issue this, that these are land owner posts, so we are not going to appear great for posts. By what authority? How arbitrary it is, Lordship. Where is the courage on them? How can they, victimizing the petitioners after 12 years, issue this kind of and say that this is too arbitrary, Lordship. It cannot stand the test of law. Page 78. Where is the courage on them? Then comes, my lord will kindly, I won't submit much, Lordship, just they are submitting many things out of the purview of what is within the pleading. That's why I'm trying to impress my lord that within the pleadings in this writ petitions and their pleadings, we will go by that. Other submission, Lordship, I leave to your Lordship's indulgence, I leave to your Lordship's wisdom. Now, what has happened is just an 110, Lordship. The first IA they filed before this honorable court, IA 136. Now here, para 6. Starting from para 3, Lordship. It is your own pleading.
Yes.
They want to, here they are saying that they want to comply with the order, and they file IA. So para 3, it says that the applicants, after receiving the judgment and order dated 6/8/2019, has taken various steps to implement the court's directive. However, the process of declaring the result is likely to take more time, and the department may not be in a position to complete the whole process within the stipulated period framed by this honorable court. As such, the applicant, by the letter number so and so dated 29/10/2019, intimate the same to the government advocate to file for extension of time before this honorable court. They always say that they want to implement the order, Lordship. And my lord will see the prayer portion at page 115. In the premises aforesaid, it is most respectfully prayed that your lordships may graciously be pleased to call for records, and after hearing the parties and on cause being shown to be pleased to grant 3 months' time to fully comply with the direction of this honorable court. Judgment and order dated 6/8/2019 passed in writ petition number 131K 2016, writ petition number 139K 2016, and writ petition number 140K 2016 in the interest of justice, and or pass such orders as your lordship may be deemed proper.
Yes.
So these are the 3 writ petition now presently before this honorable court in appeal. Then the second extension is at page 118.
Yes.
The learned additional AG herself is also before this honorable court, and this is the page 120, Lordship.
Yes.
Here her statement has been recorded. Page 20, first paragraph, second paragraph, third paragraph. The case of the applicant is that after receipt of the said copy of the common judgment and order.
Granted time.
Lordship. Then the second IA, page 122.
Again, the short time.
They certain say that they will be complying with the court's order, Lordship. Then they file civil review is at page 142. Here they sought for.
For the first time, they came with the plea that record is missing.
Yes,
Record
this is the
not-
first time where then they have been taking extension of time, and we approached the court within 2015 when we did not, ourselves was not declared. We approach the court. Now suddenly they are turning back, U-turn and twisting and saying that there is delay in latches. Where is the question of us?
The learned single judge has said that it can't be a sufficient ground for review the order.
Of course, exactly, Lordship. That is the case of the petition. Is there anything that is ambiguous, Lordship? So trying to mislead this honorable court and as a welfare state, how can a person now 20 years and respondent number one to go by his affidavit 40 years when he filed this, there is only, even if the petition is allowed or dismissed, only 12 years, 60 years, only 12 years to serve, Lordship. Isn't this very unfortunate, Lordship? And how can a state government that is a welfare state treat its citizen up to this extent and place before this honorable court? This is very absurd and this is very inhuman, Lordship.
Yes.
This is my, even if I don't submit also, my lordships are well conversant and well.
Yes, anything on you want to submit in the.
Just one lordship. So here will come Manjusri's case, page 32, where the rule of game cannot be changed when the
It's not a case of rule of changing the
rule of game after the
That is
game
not-
is over. That is with regard to they publishing the advertise.
Strictly speaking, it is not, now they are not changing the rules.
Exactly,
They come with a
exactly.
different plea.
My first will cover lordship. I have some other Supreme Court cases also, but lordship, as your lordship are very
Requirement of.
well conversant with it, I will
Yes.
not oblige.
Well, just two small points I want to make. I have already said. One is my lord, there is no vested right that they should be appointed. The nature of the petition is like that. You have a right to be considered, definitely, that's a fact. And when my learned friend sought time in this matter, it was under the bona fide belief that we have these documents. There was no reason to believe that it is not. Then when they found that it is really not with them, they had this done by SIT also. Only thereafter they came to the conclusion it is not. Now, the question is, what action have you taken against these officers? This is more than 20 years old. It is going on for quite some time. It is very difficult to pinpoint exactly any type of responsibility on any particular individual. It was not with any view to creating any harassment or so, because as has been mentioned by my learned friend, that interview was cancelled.
Yes.
And there's no vacancy as such as on date. And as far as these people are concerned, we refer to
Yes,
they refer to a document which they pointed out to your lordships at page 88. They said they pleaded it right from the beginning. It's a certificate. I will just read it for your lordship.
88, yeah.
Yeah. This is to certify that the village council of Pimla village being the landowner. So it's not that the individual is the land. So they said, we want to have a job. They said, no objection.
But they're saying is such type of certificates are
No,
granted by.
completely incorrect. I don't want to comment on it. I had the occasion because the initiative, they were not giving me the document, so she was kind enough to give it later. Whenever a certificate is issued, the certificate will state that this person is the landowner. Village council has its own land.
This is
Village
to
council
certify the
land,
Village council, being the landowner, has no.
village council, under the Nagaland Act, village council is a statutory body. That village council is the owner. They cannot mislead the court. Village council is the owner, not this person.
Does not certify the petition.
And it has not certified that she is the owner.
93.
Okay, all right.
They are not in landowner. They are not in trading of land.
And my last point, page 93, only one paragraph after that. Page 93, para 9.
Yes.
May I read it, my lord? My lord of court. That in regard to the statement made in para 12, the deponent states that certificate issued by the village council in favor of petitioner number 1 does not certify the petitioner as a landowner, and in no way can be coined as a preference certificate to consider the appointment of the petitioner number 1. The deponent states that acting on such certificates will involve some genuine landowners. So they have to certify it, because after all, you're getting a job. And when they are saying that they are the landowner, they should have been the landowner who has given the land to the government. Here even, she is not even a landowner. That's why they specifically state so. That's all I have to make. I'm
Lordship,
grateful to your lordship.
Nagaland has a very different land holding system.
I'm aware of.
In this, in all the states, Lordship. Under Article 371A, land belongs to an individual, community, and the village. So here, what is happening is till date, if it is a clan's land, they will issue a landowner certificate. And when the village authority issues a certificate, there is a village jurisdiction, and amongst the villagers for the village land.
But your clients applied as landowners or as fresh candidates?
My lord.
This was also submitted and fresh candidate also, whichever way.
No. Your clients,
Lordship.
they had applied in which category? As landowners who had given their land to the government or as fresh candidates?
As fresh candidates.
So therefore the landowner part is out.
Lordship, here, whatever is it with or without landowner certificate, Lordship, just before the honorable court.
There's the only one question.
Lordship.
Either you have applied for in the category of landowner or as a fresh.
As a fresh.
You are as a fresh, then there is no relevance of this certificate, even though if you are showing it. Since you have not applied in the category of landowner, where is the relevance of this certificate?
Lordship, I just want to placed before this honorable court because it's 20 years back and all those things have already been done by the district selection committee. But since the learned AG keep on putting this up before this honorable court, I said, whichever way.
Can't have both the way.
But it is an open advertisement as well as preference will be given to the landowner.
One advertisement, the advertisement was for casual labor, the dock employees as well as the fresh.
Yes, Lordship.
This was no.
I will just leave it to my Lordship's diligence.
Fine. So,
That will suffice, my lord.
arguments heard and concluded, judgment reserved.
Highly obliged, Lordships.
Very.
I beg your pardon, Lordship, my name is ZHIMO, but here it's wrongly listed in the first list, sir. That may be corrected. ZHIMOMI. That is my name. Obliged, Lordship.
Just give it in a slip, just give it in a slip,
Lordship.
both of your names.
Writing.
Lordship.
My name also, because it doesn't come. The name properly, right?
May I please your lordship? My lord, this item 36 to 38, my lord, these are writ appeals, my lord, arising out of a common judgment and order. My lord, the issue here is whether, my lord, the writ petitioners would be covered under the scheme of old pension, or they will come within the ambit of, my lord, new pension scheme. My lord, there are other matters. In fact, my lord, on last Thursday, 4 of such matters were listed before my lord, and the lordships had, my lord, directed for listing those matters along with these 3 months. But those matters have skipped today. And there are other matters also.
Those matters we have fixed the date of today or some other day.
My lordships had directed, my lord, for listing these matters along with, my lord, writ appeal 156 of 2023, which has been listed today. My lord, that is item number 37. And there are few, my lord, other 3 writ appeals also, apart from those listed last Thursday, there are 3 other writ appeals also, which are also required to be listed along in a series, my lord. Okay. If lordship permits, my lord, I can give the names, my lord, writ appeal number, my lord.
Learned concept for the respondent has submitted that some similar writ appeals are also pending before this court at the stage of hearing. Full stop. Learned concept of the respondent is directed to supply the list of those similar petition, similar appeals, which may be similar appeals, and all the said appeals as well as these appeals be listed for hearing before this court on 9th of April. 9th of April.
I'm so obliged, my lord.
Item 18.
May it please, my lord. My lords, I'm sorry I was not available on the last call, my lords. I'm apologetic for that, my lord. My lords, in this matter, the issue involved is whether the respondent, my lord, is entitled to payment of any gratuity. My lords, the learned single judge notes that there is, my lords, a provision for an appeal. My lords will kindly see that. In the single judge's order, if my lords could come to.
Page.
My lords, the single judge's order starts at page 30, annexure A.
Internal page of the.
30, my lords. Am I audible, my lords?
internal page is, the judgment is of 23 pages only.
Yes, my lords, with the internal pagination of the paper book, my lords, is page 30 in my paper book, my lord.
So we are asking only this, that internal page of the judgment, the impugned judgment.
Yes, my lord will directly turn to my lord. Page, internal page, my lords, 12.
Well, yeah.
1 to 12, my lord. And my lords will directly come to paragraph 15.
Yes.
And my lords will please see from the 5th line from the top there, the learned single judge notes, my lord, that there is an appellate authority which is prescribed, which is under, my lords, section 7, subsection 7, my lord, of the Payment of Gratuity Act.
Read para number 15, please.
Yes, my lords, I am reading that, my lords. It is a settled position of law that an appeal, if provided by the governing statute, is a continuation of the original proceedings and the power of the appellate authority to reappreciate and reevaluate the evidence materials placed before the controlling authority is coextensive in order to confirm, modify, or reverse the decision of the controlling authority. Conspicuously, the petitioner herein has chosen not to avail the remedy of appeal provided by the statute, instead has chosen to assail the order direction passed taken by the controlling authority by preferring the instant writ petition under Article 226 of the Constitution of India, which is an extraordinary discretionary jurisdiction. Then my lords will come to
Yes.
kindly, my lords, come to my contention on the merits, my lord, which is at internal page 18. Para 23, my lord. My lord has that.
Yes.
So my contention, my lords, is noted at para 23, page 18, my lords, which is that we are not an establishment, my lords. This is a statutory authority. The writ appellant before my lords is a statutory authority, which, my lords, deals with promotion and development of export of agricultural and processed food products. So our case, my lord, is that under the Payment of Gratuity Act, the applicability is provided for, my lords, in para 3, in section 3, I'm so sorry. And it is specifically excluded in the Shops and Establishment Act, which governs the state of Assam. It's called the Assam Shops and Establishment Act 1971. So my lords will kindly see that our entire case on merits is this, and this was the first issue, my lords, which was framed by the controlling authority. If I could show, my lords, the controlling authority's order and the issue which was framed. If I could draw my lord's attention to the controlling authority's order. Annexure F.
Mr. Consul, the dispute is in relation to only 68,000.
Yes, but my lords, what?
Why your 68,000 poor employee, you suppose that we issue notice to him and he'll come and contest this case? What is this?
My lords, what is happening? I'll tell my lords what has happened. There is another case which is pending. About, my lords, according to him, he has been retrenched. Our case is that he's a contractual employee. But he has, my lords, he went to the industrial, my lord, industrial.
If in that petition the amount is some more amount is involved.
My lords, yes, and he is, my lords, challenging. He was a contractual employee, so we terminated his service at the end of the.
What we are asking simply without going into the matter, if the money involved is only 68,000 odd rupees,
yes,
why they interfere, sir?
My lord, I am not, my lords, I bow down to that, my lords. I am not even, my lords, I bow down to what my lords is putting to me, and I have to fairly submit that it is, my lords, only 68,000. So I would not have, in a normal case, my lords, I would have not argued the matter at all, my lords.
Then
But here what has happened is there's a parallel case running, my lords, which is on his retrenchment. So we feel, my lords, that because our case in this case, as well as the other case, my lords, is exactly the same, that he's a contractual employee.
okay,
So
then
if
do one thing. Then do one thing. We'll admit this petition subject to the condition that you'll disperse this amount to the respondent. This 68,250, which would remain subject to the outcome of this appeal.
we have already deposited the money, my lords. There was an order of this court, the learned single judge. We deposited the money in the court. My lords will kindly see that.
In the
We have
court?
mentioned. Yes, my lords.
In the court.
Yes, page 10. Page 10 of my lord's appeal. I have said so, my lord. I have deposited the money. Page 10, para 13.
Page 10.
10, my lords, of the appeal paper book, my lords, para 13.
Application before the assessing controlling authority payment of gratuity, any respondent alleging that he was a regular employee. The appellant received a notice. No, para 10 of your appeal.
No, page 10, my lords. Page 10, para 13, my lords.
Yeah.
I'm so sorry. Page 10, my lords, para 13.
Para 13.
Yes, my lord.
By the order, the Honorable Court voided petition, and there is order, the notice issued, the director appellant shall deposit the awarded amount registered in the court of 3 weeks in compliance with the direction. Appellant deposit the awarded amount registered on 15/3, which was taken. Okay, so we have already deposited in the year 2013.
My lord, as per directions of single judge.
If your petition subject to the and will issue a direction to the registry to disperse the amount in favor of the respondent, that
My
would
lord.
and said disbursement would remain subject to the outcome of this.
My lords, I have a submission.
But
My lords, what?
Mr. Counsel, the money has already gone from your pocket.
It has gone, my lord.
Sorry, if the money is lying with us, it is of no use. At least the employee may use it and with an undertaking that and that disbursement will always be subject to the decision of this appeal.
My lord, they've
My lord.
received the amount.
My lord,
They have
we have
withdrawn that.
already received the amount.
You have already received the amount.
Workman, my lord.
Then what remains up now?
My lord, I was not aware of this, my lord. So this must have been a.
Right, yes. Having heard the learned counsel of the parties, we are of the opinion that the matter requires consideration, hence admit no need to issue notice as parties are already represented. List this appeal for the hearing in the month of August 2024.
My lord, we have not received any copy. We have not received any copy of the appeal.
The copy of the appeal be furnished to the counsel for the copy of the appeal along with the requisite documents be furnished to the counsel for the respondents during the course of the day. Furnished now.
My lord, there's a prayer for stay as well.
What stay?
Stay of the impugn order. my lord.
Impugned order, they have simply said there is no question of stay. The money you already paid, the amount is dispersed to the respondent. What stay?
My lord, the problem here is that there are certain observations which have been made by the learned single judge saying that he is a regular employee.
Sir,
So that may have a bearing, my lord, in the other case. That's the only thing. my lord.
Mr. Concept, bearing on the other case, how the other case is also related to the contractual employee?
Yes, my lord. The same employee, my lord, on retrenchment.
That is
Pending.
in relation to the same employee.
Same employee, my lord. That is the problem.
That is admitted, that petition is already.
No, my lord, this is going on before the learned single judge, my lord. It's at the writ petition stage, my lord. So, my lord, will kindly say the observations will not come in the way in that disposal of that petition, my lord. That's all, my lord. I will not seek a stay, my lord.
Observations, in fact, we have not seriously gone through the observations. Without going through the observation, how can we pass such type of stay orders?
All right, my lords, then I'll leave it to my lords. In fact, the only reason why I was anyways pressing the appeal was only because of that particular matter, my lords. Otherwise, as my lords have rightly put it to me, this is of a small amount, my lord.
Okay, any copy of the petition is supplied to him for? Then a concept of the appellant has prayed for passing an interim order to the effect that the observations made by the learned single judge in the interim judgment may not shall not have any bearing in the collateral proceedings pending before this court. Full stop. Having considering the prayer of the learned counsel for the appellant, we deem it appropriate to observe that since the appeal is, the appeal, since this appeal is already admitted, any observations made by the learned single judge in the impugned order may not have any, shall not have any bearing in the collateral proceedings pending before this court.
I'm deeply aware.
You have already received money. That's all. Thank you.
As per order of the honorable single judge.
That is there. We are not commenting on it then.
Next date, my lord. Date.
Thank you.